Today we're going to be talking about what would Charles Dickens say about the state of international arbitration today. We'll consider his influence on 19th century English jurisprudence and indeed the common law throughout the world and its continuing relevance today. We're going to begin with a reading from Carmel Proudfoot, who's joining me on this conversation, and she'll be beginning with the reading of a very famous passage from the book Bleak House.
Thanks, Mark. We can't introduce the topic any better than Dickens himself, so this comes from the first chapter of Bleak House. Jarndyce and Jarndyce drones on. This scarecrow of a suit has, over the course of time, become so complicated that no man alive knows what it means. The parties to it understand at least, but it has been observed that no two chancery lawyers can talk about it for 5 minutes without coming to a total disagreement as to all the premises. Innumerable children have been born into the cause. Innumerable young people have married into it. Innumerable old people have died out of it. Scores of persons have deliriously found themselves made parties in Jarndyce and Jarndyce without knowing how or why. Whole families have inherited legendary hatreds with the suit. The little plaintiff or defendant, who was promised a new rocking horse when Jarndyce and Jarndyce should be settled, has grown up, possessed himself of a real horse, and trotted away into the other world. Fair wards of court have faded into mothers and grandmothers. A long procession of chancellors has come in and gone out. And stepping back for a minute, just to put that quote into context, Bleak House tells the story of a fictional probate case, Jarndyce and Jarndyce, which ran for so long before the Court of Chancery that entire generations of beneficiaries were born and died before it was resolved. Their lives revolved around it and were ruined by the litigation, and ultimately the entire estate was eaten up in legal fees without benefiting anyone except, supposedly, the lawyers who collected their legal fees, although I suspect that if asked, they might have had a different view on whether their lives were improved by a long-running litigation. Dickens had many criticisms of the judicial system in Bleak House, but the 3 key ones which still resonate today are the length of time that it takes to resolve disputes, the costs of proceedings, and the unnecessary procedural complexity which makes proceedings inefficient and helps contribute to those time and costs. And I think that those are certainly issues that everyone on this call would be familiar with in both a litigation and an arbitration context. Now, the advent of technology since Bleak House has had the dual effect of both improving our ability to work efficiently, but also our ability to generate vast sums of papers and documents, which helps contribute to those delays, those costs, and that complexity. So having just briefly set that scene, Mark, I might pass back to you to talk about how the criticisms in Bleak House came about and how that's influenced the development of arbitration.
Thank you, Carmel. And I think to appreciate the significance of Bleak House and the writings of Charles Dickens, one needs to consider the historical context. We talked at the ICC Australia event in Perth some months ago about how arbitration in one form or another has been known to mankind for thousands of years, including being used by First Nations people tens of thousands of years ago. We can see references to the use of arbitration or equivalent means of dispute resolution in historical times in Greek mythology, in the works of Homer and Aristotle. We can see it referenced in the works of scholars during the Roman Empire, and we can see it being used in medieval England, principally by merchant guilds. But the first recorded case in the English common law that considered arbitration was Vigneau's case in 1609, where the court supported arbitration in the sense that it ordered the defendant to pay the agreed penalty for refusing to submit to arbitration pursuant to its agreement. The first statute adopted regulating arbitration in England and Wales was the Act of 1698. And if you read it now, it reveals a Parliament's enlightened attitude to arbitration well ahead of its time. You will see many similar principles and attitudes towards arbitration that we have today being reflected in that statute of 1698. But it wasn't very long after that the English courts became more hostile towards arbitration, in particular in the case of Kill versus Hollister of 1746, only 50 years after that aforementioned statute was promulgated. The courts refused to allow arbitration to proceed on the basis, this was in an insurance policy, on the basis that parties cannot agree to oust the jurisdiction of the court. Historians studying that case and others have attributed that attitude of the English courts to the fact that the judges, the court officers, and the other participants in the proceedings were themselves paid with reference to the amount of work that was taking place within the court. So they had an incentive, according to various historians, not to support arbitration. That was 1746. Let's move forward nearly 100 years, or just over 100 years, to Bleak House, which you've quoted from, Carmel, which was released in 19 monthly installments between March 1852 and September 1853. And those dates are important given a case that I'm going to talk about in a moment. Charles Dickens, in the preface to the book, noted some of the inspiration that led to his writing of it. One was a case of Jennens and Jennens, which at the time that Charles Dickens wrote Bleak House had been within the Court of Chancery for some 55 years. But Carmel, the case actually continued within the courts until 1915, some 117 years that court that case was before the courts in England and Wales. The second case that he's believed to have referenced, because he only did so obliquely, was a case called was the estate of Charles Day, which by that point had been going for 20 years and had consumed some £70,000 in costs in some 20 years. I actually did a quick calculation early today as to what that would be in today's currency, and it was only $9 million in US dollars. I say only because, of course, modern arbitration can lead to costs far greater than what was being incurred in that case that led to the wrath of Charles Dickens and his writing of the book Bleak House. Charles Dickens had his own experience to fall back upon. In 1844, he had pursued 5 actions before the Court of Chancery against a publisher of the Christmas Carol that had done so without his authority. He prevailed in that case, but was unable to recover his costs, which were said to be some £700. And again, Carmel, I converted that amount into today's currency in US dollars terms. That's only $112,000 in today's money. But still, that was enough for Charles Dickens to take a very dim view of the English courts. And it led him to express in a letter that he wrote around that time the following. He said that my feeling is the feeling common. That is, that it is better to suffer a great wrong than to have recourse to the much greater wrong of the law. I know of nothing that could come, even of a successful action, which would be worth the mental trouble and disturbance it would cost. So that led him to write Bleak House, which people describe the case that you referenced, Carmel, in different ways. I tend to refer to it as jaundice and jaundice. But that led him to create that fictional tale and that wonderful quote that you read out earlier about how ruinous the English courts could be to suitors. And that word ruinous is something, and ruined is something that he expressly talked about in the book. I've got an old copy of Bleak House, which I've been reading for about 30 years. It's extremely thick, and every time I open it now, I sneeze because of the dust within its pages. But if I may, we'll have another reading, Carmel, because I think this is a brilliant description of the courts at the time and his penmanship. And it goes as follows. He says, "This is the Court of Chancery, which has its decaying houses and its blighted lands in every shire, which has its worn-out lunatic in every madhouse, and its dead in every churchyard, which has its ruined suitor," and I think that word ruined is important, "with his slipshod heels and threadbare dress, borrowing and begging through the round of every man's acquaintance, which gives to moneyed might the means abundantly of rearing out the right, which so exhausts finances, patience, courage, hope, so overthrows the brain and breaks the heart, that there is not an honourable man among its practitioners who would not give who does not often give the warning, suffer any wrong that can be done to you, rather than come here. That is serialized in 1852 to 1853. The next case that comes before the courts in England, in particular the House of Lords, that considered whether arbitration should be supported as a matter of public policy, was of course the case of Scott and Avery, where arguments were delivered to the court in mid-1855, so some 2 years after the release of Bleak House. And the judges took some 12 months to write their decision, which was released in July 1856. And interestingly, there were some 10 judges that considered the matter, and there was a clear majority in favor of supporting arbitration, a majority of 7-3. Before I refer to the leading judgment of Lord Campbell in that case, I might just read out some of the dissents that were delivered in the House of Lords case of Scott and Avery, because it reveals the level of hostility and apprehension that there was towards arbitration at that time, which the majority sought to change. Mr. Baron Martin said that there was clear authority for the principle that arbitration should not be allowed because it ousted the jurisdiction of the courts of law and equity. And Carmel, he likened it, this idea that this prohibition against ousting the jurisdiction of the courts of law or equity in England was considered to be analogous to the principles against slavery and the principle that you could not contract in order to commit a crime. In his judgment, he likened an agreement to arbitrate to those any attempts by parties to try to agree on contracts in relation to slavery or criminality. Similarly, Mr. Justice Reitman said that an agreement to arbitrate is a mere attempt to evade the rule of law, and lamented that it would effectively take away the jurisdiction of the courts, effectively saying what the historians have said, which was that there was a concern that arbitration would reduce the amount of work before the English courts. And Mr. Baron Alderson, he lamented what is the current plight of judges around the world when the New York Convention is followed. He lamented that if arbitration was allowed to stand, it would leave the courts only with, in his words, the barren privilege of being allowed to countersign the decision and enforce payment of the sum awarded by the arbitrators. It wouldn't allow them to dig into the merits of the dispute, which he lamented. This brings us to the leading judgment of Lord Campbell, which I think is another one that is worth quoting from, because my thesis, and Carmel, I think you agree, is that I think that this reasoning is influenced by the horror that was depicted by Charles Dickens in Bleak House, because he says, and I quote Lord Campbell, "Is there anything contrary to the public policy in saying that the company shall not be harassed by court actions, the cost of which might be ruinous, but that any dispute that arises shall be referred to a domestic arbitration tribunal, which may speedily and economically determine the dispute. I can see not the slightest ill consequence that can flow from such an agreement, and I can see great advantage that may arise from it. Public policy, in his view, therefore, seems to me to require that effect should be given to the contract to arbitrate." My thesis is that that public policy shift that we can see taking place right within that very court, with some of the dissenting judges continuing to reflect the view of the past, was to a degree influenced by Charles Dickens' description of the horrors of the Chancery Court. And Charles Dickens at the time noted that his book was the most popular that he'd ever written. More copies were required of Bleak House than even A Christmas Carol or his other famous works. So perhaps I'll pause there, Carmel, and invite you maybe to talk about some of the public policy elements of the decision of Scott and Avery.
Yeah, so I think there are two aspects of Scott and Avery that are particularly interesting. The first is the one that you just touched on, Mark, which is that the court's primary concern was a public policy consideration about removing cases from the court's jurisdiction. And that's obviously another comment that you hear echoed about arbitration today, on the basis that the confidential nature of arbitration proceedings lacks transparency. It prevents the development of the common law, and it can result in conflicting decisions which decrease commercial certainty. Now, the counter-argument to that is obviously that arbitration acts as a release valve for the courts, and it can, in fact, help achieve the outcome that Dickens was pushing for in Bleak House, to improve the efficiency of the judicial system by removing cases into a neutral forum where they can be resolved efficiently. And that's particularly important in jurisdictions where judicial dockets are overburdened and it can take years to even get a trial date, let alone a final decision. But it's also very important in jurisdictions where the national court systems are ill-equipped to resolve international commercial disputes. So it's important for parties to be able to select arbitrators with the appropriate knowledge and commercial background. And of course, even in jurisdictions where the judicial system is well-resourced and it is well-equipped, arbitration helps keep things moving by providing another avenue for the resolution of disputes, and very importantly, providing that well-developed framework for the enforcement of awards cross-border, which, although the rubber stamp at the end attracted some criticism in Scott and Avery, is obviously one of the key features and benefits of arbitration today. I think the second aspect of Scott and Avery that's particularly interesting was the court's focus on the importance of party autonomy, and Justice Coleridge in particular emphasised this as one of the key reasons why the court needed to enforce the parties' agreement to arbitrate, and that has over time become the cornerstone of modern arbitration, and despite being a contentious element in Scott and Avery, is now widely supported by courts who frequently stay court proceedings in favour of a referral to arbitration. So it's interesting how those two key aspects of the decision have echoed and developed over time and become cemented in the modern system. But I'm interested in your views, Mark, on how you think those criticisms and considerations apply in today's proceedings.
Well, I think the criticisms that were being levelled at the English judiciary in 1853 probably do not apply to the English judiciary, of course, today, or the courts in Australia. But there are, of course, jurisdictions around the world where there is a massive backlog of cases. As you were just speaking, I was just rifling through my papers to gather some of the data on the backlog in the courts of India. It's been reported that there are some 314 million cases pending before the Indian courts, and Justice V.V. Rao in 2010 in a High Court decision famously said that it would take 320 years for the Indian judiciary to clear the millions of cases pending before the courts. So that backlog is not unknown in the common law world today. But I think even when it comes to England, and I think we're going to have time for some debates, and we've got people here that are practicing around the world on this call that can offer their views. I think even in England, some of the concerns expressed by Charles Dickens may continue to apply. And this is an important issue to be considering at this time when the English Arbitration Act of 1996 is under review. And I'm also minded to mention the famous speech by the Lord Chief Justice of England and Wales, Lord Thomas, in 2016, in which he was calling for, in his words, a rebalancing of the relationship between the courts and arbitration. And of course, as you mentioned, Carmel, he lamented, among other things, the lack of the development of the common law world, lack of development of the common law as a result of arbitration's increasing prominence in resolving commercial disputes. But between us on this call and subject to it being edited later, Jackie, before it goes online, some of the language used by Lord Thomas, I think, doesn't appear in the best light when considered through the prism which we have just presented of Bleak House. In particular, Lord Thomas repeated on 3 occasions in his paper his concern about the lack of diet of commercial cases before the English courts. He said that they needed to have a proper diet of cases, a healthy diet, an appropriate diet of cases. This language of eating cases, no doubt done for dramatic effect, is unfortunate, because that was the very thing that was concerning Charles Dickens, that these cases were existing only to enrich and benefit those that were participating in those cases other than the parties themselves, for whom the cases were often ruinous. And Lord Thomas talks about the benefit of allowing principles to be tested at multiple levels of the judiciary, which of course is a wonderful benefit of the court systems in England and Australia and elsewhere. But I can't help but think, who's paying for that testing of principles through multiple levels of the judiciary? But I'm not suggesting that, of course, we should dispense with the common law, or that we don't need the courts. We do, and arbitration is very much dependent upon the courts, because we apply court decisions in our cases every day. But we do need to continue to get that balance right between, of course, supporting the courts, but supporting arbitration as well. And to do that, and I think the last comment I would make is that we need to keep in mind the public policy behind Lord Campbell's decision to support arbitration. And in the quote that I read out before, he expressly referred to arbitration being acceptable as a matter of public policy because it resolved disputes economically and speedily. If we move away from that, then the raison d'etre for arbitration becomes lost. So we must always maintain that emphasis on efficiency and speed to the extent that we can, in order to continue to justify arbitration as a release valve from the courts, easing the backlog of cases before the courts, and also to ensure that there is a specialist body to resolve commercial issues. Carmel, maybe at that point, under your leadership, perhaps we could invite some questions or comments.
Yeah, absolutely. So if anyone online has a comment, please feel free to take yourselves off mute, or you can raise your virtual hand and we'll see that, or drop a comment in the chat box.
Mark and Carmel, that's a wonderful presentation to start the session, I must say. I was interested, I'm sitting in London at the moment, as you might observe, and I was in quite a complicated case involving oil concessions in the Middle East. And in encouraging the witnesses to be brief in their answers, because we're trying to deal with this case in 2 weeks, I said to them that if this case had been heard in the courts, it would have taken much longer. Privately, one of my co-arbitrators, who's a retired Court of Appeal judge, said, you know, that's not true. He said, if this had been heard in the commercial court, it wouldn't have gone for more than 2 weeks, because we are able to match the alacrity of arbitration so far as hearings are concerned, and regularly do so in the commercial court, which is quite interesting, because I think the point that there are effective commercial courts elsewhere in the world than London provides for arbitration an incentive to actually keep up to the mark. And the capacity of courts to provide as effective, if not perhaps sometimes more effective, role than arbitration is something that we all need to keep in mind.
Yes, I agree. And I personally think that it reflects healthy competition between arbitration and the courts, each trying to improve their service in light of developments that can be seen in the other. And I don't practice before the courts of England, but by all accounts, things are proceeding there much more efficiently and economically than what they once did. And it's important that arbitration keeps pace with that.
Yeah, and I think we were looking at some statistics, sort of average duration of an arbitration case as part of preparing for this. And I think the ICC in 2020 reported that the average time between commencement of proceedings through to a final award was about 26 months, which is probably on par with many of the courts in many of the developed jurisdictions. But then the longest time that an arbitration has taken is, perhaps unsurprisingly, in the investor-state context, took 22 years to resolve and ended with a finding that the claimant hadn't proven damages.
Mark mentioned India, where I've got a few cases, and I must say the challenge there, which is recognised, I think, by Indian practitioners, is that they really haven't availed themselves of what arbitration can provide, because the processes of arbitration hearings, shall I say, don't quite match best practice, if I'm sort of putting it neutrally. And so I think the message that we Australians can carry around the world as counsel and as arbitrators is that there is a capacity by arbitration to actually deliver more effective dispute resolution than some of the courts, of which India, as you've mentioned, Mark, is one of the best examples.
And we have lots of practitioners joining this call from Australia, and to be interested in any of their views on the interplay between the courts there and arbitration. My personal view is, of course, that the Australian courts are extremely efficient and effective, and probably reasonably cost effective, which presents a challenge for arbitration as to where it fits in the broader scheme of things. And in that regard, my sense is that arbitration in developed jurisdictions like Australia perhaps is best focused on certain niche areas, certain industries, whether it be oil and gas, renewables, construction, that will benefit from the expertise that you can get from being able to choose your decision makers. And other niche areas, such as the need to protect privacy or confidentiality, and then thirdly, where there's an international law element or an international party element that motivates the parties to seek a neutral location. But Bronwyn, you've got some observations you want to make from your home there in Australia.
I do. I was going to say that I agree with a lot of the comments that you've made about the efficiency of the courts and arbitration, and I think it is a harder argument to make in Australia. However, I have yet to see the chess clock hearing. I know that the courts have it available to them, but I haven't actually seen it in a case that I've been involved in. And, you know, most of my litigation is across Sydney, Melbourne. So I do think that arbitration still has the edge in terms of that, what is, you know, generally accepted as the way to run hearings. You don't go to hearing for 5 or 6 weeks. You actually fit the hearing into the time that the tribunal has set aside and the parties have agreed.
And I saw that Albert Monachino joined us, and he might say that arbitration not only competes with the courts in Australia, but also expert determination, which is becoming increasingly popular. Is that right, Albert? Perhaps he's dropped off. But back to you, Carmel.
We've got one question from Emily in the chat box, which is, do you think the lack of public commercial decisions in arbitration is a real problem? And can we address it by greater transparency measures? For example, the publication of redacted decisions. Do you want to comment on that one first, Mark?
I do think it's a problem, and I also think Lord Thomas, in his paper, does identify a valid concern, which is that in arbitration, often the same issues can be determined over and over again. Like I've appeared as counsel in many investment treaty cases, Doug and others as an arbitrator, and every single time the issues of unjust enrichment or expropriation or fair and equitable treatment, or whatever it might be, it just goes over and over again, the parties arguing the same issues and the issue having to be redecided because of a lack of publication to a degree and a lack of precedent in arbitration. So I think there is a problem, and I think that the Lord Chief Justice is right in the sense that we need the common law to continue to develop so we can apply it in arbitration, and we could probably benefit from greater transparency, as Emily says, in the publication of decisions.
Yeah, I think I agree with that. The only two sort of nuances that I would add to that is, particularly at a time when commercial arbitration is competing more and more with the courts, is that we need to balance that greater transparency without losing the benefits of confidentiality, which is often what draws commercial parties to arbitration of court proceedings, particularly in jurisdictions like Australia, where there is a strong judicial system, and the need to make sure that the process of redacting and agreeing on redacted versions of decisions doesn't in itself produce disputes and contribute to delay and unnecessary costs.
And I mentioned earlier what the value of the costs in those cases that inspired Charles Dickens would be in today's money. The two cases, each, according to him, incurred £70,000 in costs, which is about $9 million US today. Doug and others probably have experience of cases in which the amount of legal fees incurred well exceed $10 million. There are examples out there of costs being in excess of $20 million. And as a profession, we really need to avoid that if we're going to continue to justify our existence. Looks like Peter might have a question.
Right. Great conversation this afternoon. Well done, both of you. I'm not sure we're talking really about competition. I would like to rephrase the discussion around appropriate horses for appropriate courses, which leads me all the way back, of course, to that important initial discussion between client and lawyer deciding upon which way to go in respect of dispute resolution. And I think it goes back very much back to that threshold discussion, is deciding whether you go down the court route or the arbitration route. And so, to me, I'm not sure it's competition. It's competition in the sense of what each can offer, but I think really at the end of the day, appropriate horses for appropriate courses, and the obligation, and dare say, a very significant obligation, and one which could maybe at some stage get to the stage of a lawyer having to refer to his a professional indemnity insurer when that lawyer has not given his client a full advice as to the options and as to appropriate horse for the appropriate course. That's my comment.
And I agree, Peter. Certainly horses for courses, and the competition I was referring to was more of a procedural nature, that each are looking upon the practices of the other today and working out to what extent they need to evolve in order to appeal to business. What's slightly unfortunate is that the legal proceedings before the courts, particularly in England, Australia, and say Singapore, have improved so much that now the competitive advantage of arbitration perhaps is reduced. But I think that's not a reason, therefore, to start attacking arbitration. The fact that the courts themselves have evolved to match the speed and efficiency of arbitration does not mean that, therefore, arbitration, I think, is no longer a valid means of resolving disputes. But it does mean that arbitration needs to continue to evolve so that it remains attractive to clients.
Certainly.
And I'm seeing here in Singapore that there's been a big shift away from arbitration in recent years, including with not only the commercial court there in London, but the advent of the Singapore International Commercial Court here. And the courts in Australia have always had a very healthy diet of commercial cases, to use the word of Lord Thomas. But I'm seeing here that cases that only 5 years ago would most certainly have gone to arbitration some of them are now being resolved before the courts.
Picking up Bronwyn's point about chess clock, I think that if you look at the rules in the Singapore International Commercial Court, you will see the opportunity for a very substantial adoption in that court of the sort of arbitration rules that include her mention of chess clock. But I'm concerned, I must say, about arbitration in Australia, because in my first love of construction, the length of some of the Australian arbitrations in that space is unforgivable, in my opinion. And that represents, I think, a big challenge in Australia for the way arbitrations are conducted, certainly in arbitration. Next month, I'm actually going to give a speech at the Lighthouse Club in Sydney on the good, the bad and the ugly of Australian construction arbitration. But there is a lot, I think, that Australian practitioners can do to provide a service for clients in the arbitration space in construction that is not presently happening.
And I can't comment directly, Doug, but I did speak to someone last week that was here in Singapore for the IBA and had travelled here from Sydney, and said that one of his colleagues had been working on 2 construction arbitrations for 10 years. And that's all they'd done for 10 years. And yeah, that seems almost jaundice-esque.
Yeah, it's a serious issue that we need to deal with in Australia, in my view.
Thank you, Doug. Any other comments? Adrian, I have a view.
Thanks, Mark. What I was going to say about the comparison between, the commercial courts and their efficiency and, perhaps what is the extreme example of poor performance of arbitration, namely big construction disputes, is what we've got to try and compare is apples and apples. The commercial courts have become really, really good at determining short legal points. Indeed, many of the lists, commercial lists, will only list a matter if it's going to involve a hearing of less than 5 days, for example, or predominantly involves a matter of law or whatever. If one looks at, for example, in the Supreme Court of Queensland, not those cases, but the cases that get onto the supervised case list, that is the big construction disputes that get onto that. And I mean, there's a case here that's becoming bigger than Ben-Hur, if it's not already, a big fight between Santos and Fleur. Not giving away confidentiality, it's on the public record. It involved the referral out of many matters to referees, and then the challenges that seem to go on and on about the challenges to the report, the challenges to the appointment, and so on. So the courts have their own problems dealing with big factual disputes. Most of the construction type disputes tend to be, big factual fights that go on and on and on. Interestingly, where arbitration might be able to compete better with the courts is in being able to develop and establish a facility for determination of short points. That is, not the entirety of the dispute between the parties, but somehow determine preliminary points, so to speak, that would hopefully resolve the dispute in a commercial sense and get it done really quickly. And with a bit of imagination, one could design a facility which is, in addition to dealing with arbitration of the entire dispute between the parties, also dealing, for example, during a construction disputes with issues of law that come up during the project, just as an example, and in other commercial contexts as well. That seems to me, at least in Australian arbitration, what is lacking from our system. That is the ability to offer what the commercial courts are offering, whereas, big intensive factual disputes have the same problems in arbitration, it seems to me, as they do in the courts. The only thing the courts have got the advantage of in that is that they can be bolder in interlocutory rulings than an arbitrator might be willing to do. An arbitrator often being, at least at one level, constrained by the notion that it's the parties that determine the procedure. And so the arbitrator's got to try and balance that with being bold and decisive and making interlocutory rulings that will get on with the matter, notwithstanding the parties wanting to drag their feet and so on. Anyway, that's what
Adrian, I
say.
think the High Court's view on the special leave that is granted in the Chevron case from Western Australia will determine to a degree the capacity in Australia for arbitrators to make partial final awards on preliminary issues. That Western Australian decision, in my view, is a dead hand on doing exactly what you suggest, which I think is an excellent idea. But leaving it to the court to review what the arbitrators have decided when the arbitrators decided they decided something else has led me to say I will very rarely agree in Australia to the determination of a preliminary point by way of a partial final award. It's just too dangerous.
Yeah, well, that's if the entire dispute has been referred and what's being determined is part of that dispute. But if there's a facility under contracts to refer separate points as they arise, then it doesn't have that same problem. E.g., one can decide the ability of someone to give a particular notice under a contract without deciding and without even being seized of what the consequences of that would be, the damages or time consequences of the giving of a particular notice. If a dispute turns on a question of law, and many don't, as we know, many depend on intense factual analysis, which you can't do anything about other than hear it. Anyway.
Yeah, a good point.
Over to you, Carmel.
Any other questions in the chat box? Anyone in the groups got any final comments? Please take yourself off mute now. Otherwise, we're about 15 minutes over time. So thank everyone for joining today. Hopefully you found it an interesting topic. It's slightly different to our traditional conversations format, but we thought it was a good way to kick off the year.